Okay, well, everyone, thank you so much for coming. Today, we're going to be talking about the CDC Eviction Order. What is it? Who can use it? When and how? So, just before we get started, I just wanted to talk about some of our legal aid resources. So, we post updates very frequently, legal updates related to COVID 19. So, if you're interested in getting updates, please visit our website at lacsn.org. Also, you can scroll to the bottom of the homepage and connect with us on our various social media channels where we post updates quite frequently about COVID related legal updates. So we're on Facebook, Instagram, Twitter, YouTube, and LinkedIn. I think I've remembered everything, but we hope that you'll connect with us on social media. You can also, at the top of our website, there's a banner that leads to our COVID-19 resources page, and there you can download our legal and financial toolkit, which provides a lot of really helpful information for renters and for other consumers and people in the community who are, seeking legal and financial information during this really difficult time. So today we're going to be talking about the CDC order, and I believe Christine Miller has sent you a packet with the CDC declaration and proof of service and some various other materials. We're going to be posting that sometime next week on our website in both English and Spanish, so we encourage you to check back on our website then for an update. You can also learn more about our telephonic Ask a Lawyer sessions. We do have a tenants' rights session, and those do tend to fill up quickly. So if tenants have questions about evictions or other landlord-tenant matters, they can always call our main number, which I've listed on this slide, and speak with one of our intake advocates or one of our attorneys regarding their legal issue about evictions, and we'll get back to them within the same day. So we're definitely out there. We're a resource during this time for anyone who has questions about evictions. Okay, so today what we'll be covering is just briefly the status of the Nevada ban on evictions, the status of the Federal CARES Act ban on evictions, and then mostly we'll spend time talking about the CDC ban on evictions. So first of all, what is it? Why was it issued? Which landlords and which tenants are covered? What types of evictions does it prevent? What are the penalties for violating the CDC order? When does the order expire? And most importantly, what should tenants do to take action right now? And then we'll have time for review and questions at the end. Okay, so some of you might be asking, well, wait, isn't there already a Nevada ban on evictions? Well, sort of. Back in March, the governor issued a directive preventing broadly all types of evictions. And since then, it's been whittled down to right now through October 14th at midnight. There's a ban on evictions based on non-payment of rent. So right now, it's only non-payment of rent evictions that are prohibited by the governor's directive. Only for residential tenants, not commercial tenants. And this directive applies broadly to everyone. There's no action needed on the tenant's part, nothing they need to tell the landlord or to give the landlord to be protected by the governor's directive. Now, the CDC order should also operate at the same time as the governor's ban, but the two have different scopes, and we'll talk about that a little bit later in the presentation. Okay, another question that might come up is, but didn't Congress already ban evictions under the CARES Act? Well, they did. Unfortunately, the primary protections have expired over the summer. The federal moratorium has expired, but covered properties under the CARES Act who are in active forbearance or otherwise known as mortgage relief cannot evict tenants right now until the forbearance is over. And also properties that are covered under the CARES Act, these are properties with federally backed loans or properties participating in a federal program such as Section 8. They have to give a 30-day notice before evicting a tenant for non-payment of rent. So before any kind of non-payment of rent notice can be served on a tenant, they have to get a 30-day CARES Act notice first. The one problem is that it's often difficult to determine if a property is covered by the CARES Act. We do have online lookup tools for Fannie Mae, Freddie Mac, HUD, National Low Income Housing Coalition, ProPublica. The issue is that none of these online lookups are really comprehensive. So we have to cross-check them, and hopefully one day soon we're going to have a more comprehensive database where we can go in and verify that a property is covered under the CARES Act and would have to issue the 30-day notice before evicting a tenant. Okay, so the CDC order, what is it? On August 8th, President Trump issued an executive order that directed the Centers for Disease Control to consider whether to halt evictions, whether the halt to evictions was reasonably necessary. And then about a month later, the CDC issued an agency order under Public Health Service Act, Section 361, to temporarily halt residential evictions to prevent the spread of COVID-19. And now this agency order can be found in the Federal Register. And we will have that on our website, I believe. And also, you can just look it up on the CDC website if you want to see the full text of the order. So why was the CDC order issued? Essentially, it was to stop the spread of COVID-19. And what the CDC order says is that it's to be interpreted and implemented to mitigate the spread of COVID-19 within congregate or shared living settings or because of homelessness, to mitigate the spread of COVID-19 from one state to another, and also to support the response efforts of state, federal, and local governments. So really it was meant to keep people from being evicted so they wouldn't have to be in shared homes or out on the street where they're in much higher likelihood of contracting the virus. So what does the CDC order actually do? So in the language of the order, a landlord or owner of residential property or other person with a legal right to pursue eviction or possessory action shall not evict any covered person from any residential property in any jurisdiction to which this order applies for the effective period of the order. And so we'll break that down, who it applies to, what landlords, what tenants, and how a tenant can be covered under the CDC order. So which landlords are covered? Well, a landlord is what you think of as the person that you deal with every day, the person you pay your rent to, or if something breaks in your apartment, or if you want to talk about your lease, that's the landlord, the person you talk to about these things. Owner of a residential property. So what exactly does residential property mean? Well, it means any property that's leased for residential purposes. And this also includes mobile homes and people who rent mobile homes and the park space within the mobile home park. Unfortunately, it doesn't include hotel, motel, guest house rentals to temporary guests or seasonal tenants. This one we're going to need to look at a little bit more closely because a lot of weekly rentals will characterize themselves as hotels and motels and try to evict tenants on that basis, try to lock them out or to not give them the protections that a tenant ordinarily would have. So when we have a caller who's living at, what is termed a hotel or motel, sometimes it's really a weekly, and weekly tenants are covered under the CDC order, which we'll talk about in a little bit. The other type of landlord that is covered is other person with legal right to evict, and this broadly includes corporations, companies, firms, partnerships, agents of the landlords, property managers. So now we'll get to what tenants are covered. So the CDC order says that a covered person is a tenant who provides the landlord or owner with a declaration under penalty of perjury saying that they meet the following 5 criteria. And we'll go through these one by one. So number 1, the first criterion is I've used my best efforts to obtain governmental assistance for rent or housing. It just means that you've done everything you can to try to get rental assistance or other types of governmental assistance to pay your rent. As for best efforts, it's hard for us to say exactly what best efforts are. That will potentially be defined by a court. So if a tenant asks, what are my best efforts? Really, it's doing everything you can. Number 2, I'm unable to pay the full rent due to substantial loss of household income, loss of work, reduction in hours or wages, or extraordinary medical expenses. And this will generally be related to COVID, like someone's lost their job due to COVID, someone has experienced a reduction of hours, they're waiting on their unemployment, the change in income usually will be due to COVID-19, but specifically in the CDC order, it doesn't actually tie it to COVID-19. It's probably a better argument if the tenant lost income or lost wages and hours because of COVID. Okay, so the third criteria that they would have to meet under this declaration is I'm using my best efforts to pay partial rent as circumstances permit based on non-discretionary expenses. So again, we can't define what best efforts are. It's really just you're doing everything you can to make partial rent payments as you can afford them. Number 4, eviction would make me homeless or make me move into close quarters and shared living settings. So this is really what the CDC order is designed to avoid. People having to congregate in shared homes and shelters, be out on the street, anywhere where their risk of contracting the virus would be higher. And criterion number 5 is you expect to earn under $99,000 in 2020 or jointly $198,000. Or you were not required to report your income in 2019, or you received a stimulus check under the CARES Act. So if a tenant can truthfully attest to all 5 criteria, they would sign the CDC declaration and provide that to their landlord, letting the landlord know that they are a covered person under the CDC order. Okay, so what tenants are not covered? So anyone who doesn't give the declaration to the landlord, so they might meet all the criteria, but if they don't give the declaration to the landlord, unfortunately, it's not going to help them to show that they're a covered person under the CDC order. Another category of tenants not covered, anyone who can't truthfully sign the declaration because they don't meet all 5 criteria or they don't meet some of them. Maybe they haven't used their best efforts to apply for rental assistance. They make too much money, they exceed the income limits. They're able to pay full rent, or for whatever weird reason that they're unable to or unwilling to pay full rent. They haven't used their best efforts to make partial payments under the circumstances, and eviction would not render them homeless or forced group living. So if they can't say truthfully all these things apply, then they wouldn't be able to truthfully sign the declaration. Another group of tenants not covered is occupants of hotels and motels. So this is not weeklies. This is not someone who's staying at, for example, the Budget Suites, the Siegel Suites, Sportsman's Manor. Those would all be weeklies, weekly tenants, which are provided for under Nevada law. But if you're just a hotel or motel guest, like if you're staying at the Tropicana Hotel or something, that would not be the type of tenant that would be covered. And homeowners in foreclosures also not covered under the CDC order. Okay, so what does the CDC order actually prevent? So it prevents any action by a landlord, owner, or other person with a legal right to pursue eviction, possessory action, to remove or cause the removal of a covered person from a residential property. So what this means is basically the landlord shouldn't be taking any action to evict the tenant. And specifically, under the CDC order, is serving an eviction notice prohibited? Maybe. We say that it is, but maybe, maybe not. Is filing an eviction complaint prohibited? Meaning the landlord actually files a complaint with the court to get the eviction process started? Probably that's prohibited. Is the constable coming to lock out the tenant after an eviction prohibited? Almost certainly. And so now we'll just talk a little bit about the summary eviction process. So this is an overview of the summary eviction process for non-payment of rent. So a tenant is served with a 7-day notice to pay rent or quit. And they can leave, they can vacate the property within the 7-day notice period. That's not an eviction. If the tenant fails to vacate or pay rent within the 7-day notice period, they can file an answer with the court, and the landlord will then file a complaint in most cases. So it's different. It's the reverse order of a civil lawsuit where it's the complaint first and then the answer. Here in a summary eviction, it's the answer first and then the complaint. Assuming the tenant filed a timely answer, a summary eviction hearing will be scheduled and held where the 2 parties can present their arguments for and against the eviction. At the end of the eviction hearing, the judge will make a decision whether or not to grant the eviction. If the eviction is granted, the eviction order will be entered and then sent to the constable's office electronically. After the landlord pays the constable posts the eviction order on the tenant's door, noting the date on which the lockout will be done. So the tenant would have 24 to 36 hours to vacate the property. A tenant can file several post-eviction motions, or they'll leave, or the constable will come back and actually lock the tenant out of the premises. So hopefully this is an overview to help you understand kind of what the CDC order is intended to prevent. So just going back to the earlier slide, So serving an eviction notice, is that prohibited? Possibly. So that's this the very top where the tenant is served with a notice to pay rent or quit or some other type of eviction notice. That probably or maybe is prohibited. Filing an eviction complaint. So going back to the original slide, this is after the tenant answers, the landlord can file a complaint. Is that prohibited? Probably. And is the constable locking the tenant out? Is that prohibited? All the way down at the end in these red boxes, constable requires the tenant to vacate the premises. That is almost certainly prohibited by the CDC order for a covered tenant. Okay. So what types of evictions does the CDC order cover? Well, it doesn't prevent evictions for what we in Nevada would consider nuisance evictions, and those would include engaging in criminal activity, threatening health or safety of other residents, damaging the property, posing a risk of damage, or violating a building code or a health ordinance. So those types of evictions, nuisance evictions, are permitted to go forward. Same with lease violation evictions. So if you violated a contractual obligation that has something to do other than relating to rent or payment to the landlord, someone could potentially be evicted, and the CDC order would not prevent that. So presumably the CDC order does preclude all other types of evictions. So this is for non-payment of rent, lease violation, lease expiration, no cause evictions, tenancy at will. That's kind of an eviction for, let's say, an overstayed house guest or something like that, or lease violations relating to money. These would be prohibited by the CDC order. Okay, so another question that might come up is what happens to unpaid rent and fees per the CDC order? So the CDC order doesn't waive rent or fees. It just prevents eviction based on those based on the rent or fees. So the tenant, it doesn't give leave to the tenant not to pay rent. The tenant's still obligated to pay their monthly rent. Rent will continue to accrue. The tenant will still owe it all at the end, and the landlord can pursue remedies such as taking the tenant to small claims court to get a money judgment for the back rent. The tenant still can be charged late fees, penalties, and interest if it's allowed in the lease. And in Nevada, under Nevada law, the late fees are capped at 5% of the base rent. So a tenant can't be charged more than 5% of their rent in late fees. And similarly, under the Nevada moratorium, it's also not leave to not pay rent. Rent is still going to be owed by the tenant, except there are no late fees during the moratorium period. From 3/29 to 9/1, landlords can't retroactively go back and charge those late fees. So the CDC order and Nevada moratorium are similar in the way that they approach rent still being owed and to some extent the late fees. Okay, so if someone violates the CDC order, what are the penalties? And the penalties for landlords are actually pretty serious. So they can be fined, individual landlords can be fined up to $100,000 and or 1 year in jail. And if a death results, meaning essentially that they've evicted a tenant who's covered under the CDC order, and that tenant then contracts COVID and passes away, the landlord would potentially be fined $250,000 and or one year in jail. And for businesses or organizations doing business as landlords, they could receive a fine of up to $200,000, and if a death results, a fine of up to $500,000. And so for tenants, the CDC order doesn't actually discuss what happens to a tenant who makes a willful false statement or signs a declaration under penalty of perjury, which is not truthful. Those would be state penalties for a willful false statement or an unqualified statement without knowledge. And that is a fine of up to $5,000 and jail of up to 4 years. So when we talk to tenants and let them know about the CDC order and their rights under it, we tell them to read it very carefully. And if they are not certain that they can sign under penalty of perjury because all of those criteria don't apply to them, then we'll let them know not to sign, because the penalty for making a false statement is pretty serious. So when does the CDC order expire? So it says the effective period of the order is from September 4th to December 31st. So all the way from early September till the end of the year. Unfortunately, the order is currently being challenged in federal courts across the country. Right now, we're aware of a lawsuits in Atlanta. I think there's one in Ohio, another one in Memphis, where landlords are basically saying that it's unconstitutional and they're seeking injunctions to have the CDC order not apply to them and have evictions go forward. Um, so far in Nevada, we haven't gotten a decision from a court about the applicability or constitutionality of the CDC order. Potentially, Nevada courts could find that the CDC order doesn't apply until October 15th when the statewide moratorium ends. Probably not likely. The CDC order doesn't apply in states with moratoriums that offer equal or more protection. And here, the CDC order is actually offering more protection. So we would argue that the two run concurrently, the CDC order and the governor's moratorium through October 15th. And then from October 15th through the end of the year, the CDC moratorium would kick in to protect tenants all the way through December 31st. And the effective period for the Nevada moratorium, which is non-payment of rent evictions only that are prohibited, is 10/15/20. So as of that date, landlords can start the eviction process for non-payment of rent. So what should tenants do to ensure that they're protected under the CDC order? Well, first, as I mentioned, they should determine whether they truthfully qualify, whether all 5 of those criteria can be met, and if they can truthfully sign the declaration. If so, every person in the household that is on the lease should sign a declaration. And those will be on our website, and they're also available on the CDC's website as well. They should give a copy to the landlord, but also keep a copy to themselves for themselves, because potentially they'll have to go to court. If the landlord does go through with the eviction process, they may have to argue to the judge that they're covered. So they want to keep a copy of that declaration. They should also keep proof of how it was delivered. There's actually no legal requirement that they keep proof or that they file proof with the court. We're recommending that they send the declaration to the landlord by certified mail so that they have some kind of proof of mailing. If that's not possible, because we know that for a lot of our clients, they're very low income, and so certified mail can cost like maybe $6 to $8, which is kind of cost prohibitive right now. So they can send it by email and then print out the email if they potentially have to go to court. They can deliver it in person to their landlord, have the landlord sign and date their copy. And then also included in the CDC packet that we're going to post on the website, it'll have a declaration of service. And so if the landlord chooses to ignore the fact that their tenant has given them a declaration and that the tenant is protected under the CDC order and still moves forward with that eviction, we're recommending that the tenant file the signed declaration as well as a proof of service that it was received by the landlord, file that with the court and an answer to the eviction notice if the eviction process has started. But if the eviction process hasn't started, if the landlord looks at it and says, okay, this tenant is covered, not going to take any action, then there's nothing that the tenant needs to do at that point. They don't need to file anything with the court. So for the CDC order, when should tenants give the declaration? So they should give it now. There's really no reason to wait. Each tenant on the lease, each adult who has signed the lease should give it to the landlord if they qualify, meet all 5 of the criteria. There's no deadline to give the CDC declaration to the landlord. It can be any time before removal. So the CDC declaration, if the tenant is covered, it's intended to stop their removal from the unit. And of course, preventing the removal from the unit will prevent the spread of COVID-19, which is the impetus behind the CDC order. So can they attach it to their answer if an eviction has already started? Yes, they can do that. Can they take it with them as evidence at their eviction hearing? Yes. Can they attach it to any post-eviction motion, such as a motion to stay or a motion to set aside? Yes. Can they even give a copy to the constable, like when he comes to post the eviction order or comes to lock out the tenant? Yes. But the most important thing to remember is that you can do all of these things with the with the CDC declaration, but you have to provide it to the landlord. That's the only way it's effective. So some other questions we've gotten are, should a tenant submit proof to the landlord? Meaning that for all 5 of the criteria on the CDC declaration, should they provide proof like documents, tax returns, emails, correspondence, anything that will prove that they meet all 5 criteria. Well, it depends. It's not required by the CDC order, so it's up to the tenant. They might want to do that to avoid problems in the future if the landlord kind of questions them on it. But if the landlord decides to go through with an eviction, they should definitely take that proof to court with them to show the judge so they can make an argument. I am covered, and here is my proof that I meet all 5 of these criteria. So another question is, if a tenant gave a declaration, should he still file with the court in response to an eviction notice? Yes, definitely. A tenant should not ignore an eviction notice. They shouldn't say, well, because I gave my landlord the CDC declaration, I'm covered. Well, technically that's true, but the landlord will, in this situation, the landlord's serving an eviction notice, they're still trying to go through with an eviction. So yes, the tenant should absolutely fill out an answer and attach a copy of the declaration and proof of service to that filing of the answer with the court. Third question, will a tenant who gave the declaration still have a court hearing? Maybe. It depends on the court and the landlord. So a tenant who gives the CDC declaration might have a landlord who takes it very seriously and says, okay, this tenant is covered. I'm not even going to pursue eviction. However, the landlord still might pursue eviction, might serve an eviction or an eviction notice. The tenant will answer. Landlord will file its complaint, as we went through with the summary eviction flow chart, and still get to the point where the tenant has a hearing. And in that case, the tenant can bring their proof that they're covered under the CDC order, file the CDC declaration and proof of service with the court, and then show up prepared to make the argument that they are covered. Oh, and it looks like we have a couple of questions. We've got a question here. If a tenant meets the covered person requirements, but their lease expired at some point after March 2020, are they still protected by the CDC order? Okay, so being a covered person, meaning they can meet all of the requirements in the CDC declaration, their lease expired at some point after March 2020. Are they still yes? In that case, yes. If they could, truthfully attest to the fact that they meet all 5 criteria, they've given the declaration to the landlord, then the CDC order would preclude an eviction based on a lease expiration. So yes, in that case, I would say the tenant would be covered. Still protected by the CDC order. Okay, second question, if a tenant is unable to unable to apply for rent assistance because all portals are closed or relief agencies are unable to process new applications, are they a covered person under the CDC order? That's an interesting situation. So I know for the first criterion, they have to attest that they have used their best efforts to apply for governmental programs or rental assistance. And if all avenues of them potentially getting rental assistance have been foreclosed at this point, and they've truly tried everything, then I would say yes, on that first point, then they would meet that first point. As for the other ones, I'd have to kind of evaluate on a case-by-case basis. But yes, I think they would meet the first criterion. Okay, those are great questions, so thank you. Okay, so we'll move on to the next slide here. Oops. Okay, so just in review, just looking at it in a broader timeline. So right now, through October 15th, tenants are protected under the Nevada moratorium on evictions. All non-payment of rent evictions are currently banned. No action is needed by the tenant. There's no state declaration or anything like that they need to give the landlord. The CDC is also operating at this point, the CDC order to ban other types of evictions except for nuisance and lease violation evictions, if the tenant qualifies and gives the signed declaration to the landlord. So right now we have 2 different ways that tenants can be protected: statewide moratorium and then the federal moratorium under the CDC order. October 15th through December 31st, after the expiration of the statewide moratorium, the CDC order would operate to ban non-payment of rent and other types of evictions, again, except nuisance and lease violation, if the tenant qualifies and gives the signed declaration to the landlord. So October 15th through the end of the year, Nevada moratorium is gone, CDC order remains in place. And then what happens from January 1st, 2021 going forward? So CARES Act covered properties like we talked about at the beginning. they still have to give a 30-day notice before they can serve an eviction notice to a tenant. So this provision of the CARES Act doesn't sunset, so it's not going away anytime soon that we're aware of. CARES Act covered properties still need to do the 30-day notice. Same with properties in forbearance. Properties in forbearance right now getting mortgage relief, they can't evict anyone. Once their forbearance is over, if they're a CARES Act covered property, they must give the 30-day notice before serving any kind of other eviction notice.